Hi, everybody. Tom Carpenter here, hoping everyone can hear me. If there's anybody, if there's any problem with my audio, please feel free to mention it in the chat. We are live on my Facebook page, LinkedIn, and also my YouTube channel. And I'm going to present my screen at this point. So today we're talking a little bit about protecting yourself from legal risks. So this is basically oh, and thanks. I'm glad you. Thanks, Helene. I'm glad you let me know that I can be heard. So, we're talking about protecting yourself from legal risk today. Um, in light of the fact that in my law practice, I was getting a lot of inquiries about the recent situation where there was a lawsuit filed against a um, uh, agency in Arizona. So, let me just get a few preliminary things out of the way. This is where you can find me if you have any questions or need to reach out to me. A few professional responsibility disclosures to get out of the way. This might be viewed as attorney advertising, so I'm disclosing that. But this is for informational purposes only. I am not intending to provide specific legal advice in this webinar. By participating in this session, we're not creating an attorney-client relationship between my firm and you or your business. If I already represent you, obviously that's different, but just by viewing this webinar, I am not your attorney. Um, prior outcomes don't guarantee future results. That's also true in life as it is in the law, but just because a court decided something one way or language was interpreted one way doesn't mean that the next time it's looked at, it's going to have the same result. Just a few things about me. I'm an attorney in private practice, primarily representing clients in the arts, entertainment, media, and travel industries. I spent most of my career as a labor and employment lawyer in the entertainment industry. I am licensed to practice in New York and Illinois, but also at the federal level, including the United States Supreme Court. On transactional matters, I have clients in nearly every state. So drafting documents and policies. I represent at this point about 1,700 travel agencies and tour operators. So that is a lot. And then in addition to my law practice, I also have I am also the owner of a travel agency, a small hosted travel agency. So I do the same types of things that you all do on a regular basis. If you've seen other webinars that I've done or been to conferences where I've spoken, you've seen a version of this slide before. And I just like to start off every presentation by reminding people that travel is a high-risk industry. We encounter risk every day when we sell travel, ranging from fraud and scams, handling client payment information, chargebacks, defaults and bankruptcies. Travel is highly regulated, so legal compliance and disclosures are important. And what we're going to be primarily talking about today is what happens when something goes horribly wrong on a trip that you've booked for your clients. And we just went through the pandemic a few years ago. Now there are geopolitical tensions that are leading to war and terrorism. Natural disasters are becoming more and more frequent. If you're surviving the heat wave today, you understand that on a very fundamental level. And accidents can happen, resulting in injury and even death. So the good news is that as much as all of those areas of risk are things that we're confronted with, all of those areas of risk are problems that have solutions. So, when we get into this, I feel like a lot of times when I give these presentations, I wind up scaring the heck out of people. But the important thing to keep in the back of your mind is, or in the front of your mind actually, is that none of these problems are without solutions. There are solutions to everything that we're going to talk about today that's a problem. So having a well-crafted terms and conditions document is critical. How you talk to your clients about safety is important. Having a solid and consistent workflow, I think that's almost as important as having documents and policies, is making sure that you're implementing them the right way. Using a good solid tech tool, errors and omissions insurance, setting up your business in the proper organizational form, and on things like what we're going to be talking about today, you don't want to turn yourself into a tour operator. So the situation that's leading people to reach out to me most recently is a situation where an Arizona, I'm sorry, a couple from El Paso, Texas, went to a resort in Mexico. It's really a horrible story. There was bad wiring in the hot tub. The gentleman here stuck his foot in the hot tub and was electrocuted, fell into the pool, into the hot tub rather, and drowned. His wife was tried to pull him out. She was also shocked. It's a horrible, horrible tragedy. But of course, it's not surprising that there would be a lawsuit. And a lot of times when these lawsuits are filed, they bring everybody and anybody into them. So not only was the resort sued, but the travel agency was also subject to the lawsuit. So the booking agent doesn't obviously have control over the fact that the wiring in the hot tub wasn't safe, that there was an electrical current in the water, that the resort didn't maintain their equipment properly, apparently. But because the travel agency sent them to that resort, they're now facing this lawsuit. So how do you deal with something like this? The first thing I think that's most important, and I spend a lot of time talking about this with people, and I spend a lot of time drafting, I spend a lot of time drafting these documents as well. Terms and conditions documents are critically important. A terms and conditions document is a document that's contractual in nature, and it should be the boilerplate for all of the trips that you book. It's structured as a legal agreement. Because it's a legal agreement, you need your clients to actually agree to it. Putting it in the footer of your email signature, it doesn't create a binding contract for somebody to read your email. They need to actually agree to your terms and conditions. And I have a strong view that you need a custom document that is specific to your business. We're going to be talking a little bit about limitations on liability and liability waivers. There are some states where lawyers call them exculpatory waivers, where waivers that are signed are not in advance of a problem are not enforceable by law. If you exist in one of those states, I can virtually guarantee that the cookie cutter form that you subscribe to, or that you've purchased from somebody else, or that you've lifted off of somebody else's website, is not going to cover you if you're in one of those states. There are ways around that, but you should contact an attorney to talk you through that. Okay, terms and conditions documents. This is a slide that I recycle a lot, but these are the 5 main categories of things that go into a terms and conditions document, and I'm going to talk about them with a little more specificity related to the Arizona agency that's getting sued by the couple in Texas. First category is legally required disclosures. If you are I mentioned earlier that travel is a highly regulated industry, so there are all sorts of things that the Department of Transportation requires you to disclose, seller of travel numbers, things like that. Your role as a travel agent versus your role as a travel advisor. And this is implicated a little bit. We'll talk about it in a little more detail, but as a travel agent, you are the booking agent for the supplier, which means you have a fiduciary duty to the suppliers that you book. You're not allowed to undercut their pricing. You're not allowed to misrepresent their product. But as the travel advisor, you also have a duty of care that you owe to your clients, meaning you have to use your best professional judgment when booking travel for them. And so the lawsuit that's filed in this case is essentially alleging that the travel agency in booking travel to that resort was negligent because they booked them at a resort that was not safe, that had safety conditions that were unsafe. And as a result, the travel agency breached their duty of care to the client. Advisories to clients. There are all sorts of things that courts have said that you are obligated to disclose to your clients when you're booking travel for them. So advisories on risk and safety, of course, is a big one. So you'd want a provision in your terms and conditions document that advises them that there is the possibility that unsafe conditions could exist. It's their responsibility to decide whether they want to take the trip. And just because you sell the destination or the resort, you're not making any promises that it's 100% safe. Those kinds of advisories can go in your terms and conditions document, and your client is agreeing that they understand that it's their responsibility to decide whether they want to go on the trip. Cancellation and refund policies. This is really more important related to chargebacks, which is a whole different topic. But needless to say, you need to have references to cancellation and refund policies, including the supplier policy. The last one, and this is the big one, limitations on liability and force majeure. So limitations on liability waivers. These are the provisions where you're telling your clients that because you are the booking agent and not the supplier, that you are not responsible for anything that your suppliers or vendors do or fail to do that leads to damages, injury, or loss. So the resort didn't inspect their hot tubs for safety, that the wiring was safe. There was an unsafe condition there, that just because you sold that product, that you don't have any specialized knowledge of the conditions at that resort, and your clients can agree in your terms and conditions document that they cannot come after you for things that are outside of your control, like supplier bankruptcies, supplier policies they don't like, but most importantly, an unsafe condition like this. It could be something else. A motor coach goes over the side of a cliff. The helicopter crashes on the glacier. I mean, just think of the worst things that could happen to one of your clients while they're traveling that are things that you don't have any control over. And the limitation on the liability can take you off the hook for that. Force majeure is a little bit different. Force majeure is basically saying that you're not responsible for things that are unforeseen, unpredictable, outside of your control. So that would be things like war, terrorism, extreme weather events, those types of things. So again, the key provisions in your terms and conditions document as it relates to this situation with the Arizona agency that's getting sued. You want your clients to agree in your terms and conditions that they understand that your company, your agency, is functioning as the booking agent and not the supplier. When I draft terms and conditions document, that is in the very first introductory paragraph to every terms and conditions document that I draft, that the client agrees and they understand that your agency is functioning solely as the booking agent and not the supplier. So if you do things like take net rates and mark them up, collect payments from clients, those types of things, it might not be clear to your client that that's your role. They might think they're buying the trip from you, but if you are sticking in the lane of the middle person, that protects you from a lot of liability. And if your clients are acknowledging in your terms and conditions that they understand that your role is as the middle person and not the supplier, that is going to be really helpful to you in terms of taking yourself out of responsibility. The limitation of liability or responsibility provisions, the liability waivers that I talked about. Again, if you are there are some states where those exculpatory waivers are not enforceable, and so you may need to have the law of a different state applied in your jurisdiction. But your attorney can help you navigate through that. But again, you are not responsible for anything that your supplier does or fails to do that leads to damages, injury, or loss. Force majeure, Sometimes these injuries can happen because of things that are unforeseen, unpredictable, outside of your control. War, terrorism, extreme weather events. You don't have control over those things. If you can't do something that you're supposed to do, or if your supplier can't do something they're supposed to do, having force majeure language in there can be useful. A risk and safety advisory. In every terms and conditions document I do, I advise people that there are risks when you travel. There could be high crime, there could be COVID, there could be unsafe wiring in the hot tub. And that if people have questions or concerns about whether or not it's safe to travel, it's their responsibility to investigate that for themselves, look at the government websites, see if there are any advisories or alerts, and decide for themselves whether they're comfortable taking the trip. And then lastly, a complete agreement provision. And this is this is boilerplate in most contracts, which basically say that nothing that I say to you in a phone call or an email or a conversation undercuts or undermines your terms and conditions. So hypothetically speaking, somebody asks you, hey, I heard there's a problem with the wiring at the hot tub at that resort. And you say to them, oh, I'm sure it's fine. Well, you've got language in your terms and conditions that say that you don't have any specialized knowledge about that. So what you've said to them doesn't undercut what's in your terms and conditions, because a lot of times, I mean, that you still shouldn't be telling people that things are completely safe. But we'll talk about that in a minute. But the bottom line is, if you slip up, or if one of your sub-agents or independent contractors says something that counteracts what's in your terms and conditions, you need this provision, the complete agreement provision, that makes it clear that nothing that you say to them outside of those terms and conditions is legally enforceable. And to that point, let me just talk about the last situation that came up before this one, which was a Texas firefighter who went to a resort in Mexico, and there are differing versions of what happened. But that the agency that booked that trip was sued, and the pleadings in that lawsuit say that allege that the travel agency had put on Facebook that Mexico was a safe destination, nothing bad would happen to you in Mexico, and because they put that on their social media feed, when this accident happened and the firefighter died, they filed a lawsuit saying, you told us it was safe, we relied on your representation. So when people ask you, is it safe to go to Mexico, you should not be answering that question. And so this is what I say to my clients in my travel business. If somebody says, oh, is it safe to go to Israel right now? There's a war happening. Is it safe to go to Mexico? I've heard there's crime there. Is it safe to go to get in the hot tub at the resort because I heard there was a problem? Is that a problem that exists everywhere? What I say to people is, everyone has a different opinion about what's safe. I might have a different comfort level than you do about the trip you're taking. So you should review the advisories and alerts on the relevant government websites. You should go to the State Department website and see what they say about travel to Israel right now. And you should decide for yourself whether you're comfortable taking the trip in light of what you find when you go there. So again, it's kind of a non-answer, but it's the right answer to give, because if you say to them, oh, I'm sure it's fine, you're not going to have a problem, I go to Mexico all the time, that's going to be something that could potentially result in a lawsuit like the one that was filed in the Arlington firefighter case. Once you have a terms and conditions document, you have to get your clients to actually agree to those terms, because it's not a contract if they're not agreeing to it. So what I suggest doing is using a client agreement as a shorter, more user-friendly way to get people to sign on to your terms. So the client agreement is something where you can upload your terms and conditions to your website, and rather than sending 11 pages of legal stuff to your clients every time they book a trip with you, you can have them check a box on the form that they agree to your terms and conditions. You can also include your fee structure in there, which might vary from trip to trip. Insurance advisories, letting them know that insurance is available, that they can purchase insurance if they if they want to protect themselves against risk. And then any other provisions that are important for you to acknowledge. So in your client agreement, having them check a box that says, I'm hiring you to plan my trip and I agree to your terms and conditions, which are located at this link with a link to where you've put your terms and conditions. It's easy for them. People are used to checking a box. You can do that at the front end of the relationship. And you should also be doing it as part of your credit card authorization, by the way, which, again, I'm not going to cover credit card authorizations and chargebacks, but actually, I'm going to go back to that page. You just be aware that the credit card companies are now requiring that in order for you to win a chargeback dispute, you have to have a terms and conditions document. So if you think, oh, I've never had a problem, I don't need this, it's not optional anymore. You have to have a terms and conditions document, has to have cancellation and refund policies, and you have to get your clients to agree to those terms and conditions as part of the authorization in the right way. If you need help with that, you should reach out to an attorney to talk through how to go about doing that. Okay, workflow. I think the workflow is just as important as what's in your document because, again, it doesn't do you a lot of good to have these really great protections in your terms and conditions document if your clients aren't actually agreeing to it. So a simple workflow, it's very linear. Right here, you do an intake call. After the intake call, you send your client agreement. They agree to your terms and conditions at the front end of the relationship. You send an itinerary and a quote. You book it, and you get a credit card authorization for that booking. And then you send them an insurance quote, whether they ask for it or not. And then you follow up with them after they take the trip to find out whether you need to circle around with your supplier to do something to take care of them. So very simple, very linear. If you hit those steps every time, you don't have a lot of you're not making it up as you go along. The simple linear workflow is going to be your friend because it helps ensure that you're not missing a step. And again, your clients need to actually agree to your terms. You don't want to rub their nose in the legal stuff. I've made a joke about this picture that look at this client, look at this couple. They're very much in love, and they're booking a trip with their travel agent, and they're agreeing to the terms and conditions on the computer, but they're not really paying attention to what they're agreeing to. They're just checking the box, and then they're going to book their romantic trip. And then they're going to enjoy the rest of their evening. But anyway, the point is that there's not a contract if they're not agreeing to it. So you want to upload the terms to your website, make it conspicuous, make it so that your clients can find it. They shouldn't have to search for it. You need a link to it. But checking a box is enough to form a valid agreement. And whether that client actually reads the terms or whether they're paying attention to their girlfriend instead doesn't make a difference. If they check the box, you're covered. Waiving a legal right, that's different. So there are things like photo releases that I don't put in terms and conditions documents because people have the right to not have their vacation photos used to advertise your business. So I would recommend that you actually get a signature on a photo release for something like that. Also, just one other thing too, if your clients are agreeing to your terms and conditions as part of a credit card authorization, you probably have an e-signature function in the tech tool that you're using. So you are getting a signature there, which is great. On the subject of tech tools, you really want to have a tech tool that allows you to create customized forms, that transmits credit card numbers securely, that has some sort of e-signature function so that you can get a signature on your terms when they check that box. And even you need them to keep a record and track when your clients are submitting those forms. So there are lots of good tech tools that are out there. Some of them are specific to the travel industry. Turn is a relatively new tool. Travefy, TravelJoy, all have the ability to do these things. Vacation CRM, Tess, Dubsado, and there are even some forms, some tech tools that are Vacation Creation. I shouldn't forget them. A lot of Disney agencies especially use that tool. But there are lots of tech tools that are out there that do these things, and find one that is easy for you to use, and because the one that's right for you is the one that you're going to use. So definitely make your peace with technology and make that your friend. Okay, aside from terms and conditions and workflow and the advisories that you're giving to your clients, there are a lot of people who come to me who are very new to the industry, and many of them have not yet set up a formal business structure for their business. So they're operating as sole proprietors. And what you need to know in terms of liability, if you are a sole proprietor, you are your business. You and your business are the same legal entity. So if somebody sues your business, it's like they're suing you personally. The great news is you're taxed as an individual because your business is you. But the problem is you don't have any protection of your personal assets from the liabilities of your business. So if you are fined by the IRS, if you are sued by a client, and you have a legal judgment to pay or a fine to pay, your house, your savings, your retirement, all of that is potentially at risk because your personal assets are subject to the liabilities of your business. If you're a corporation, the good news is your personal assets are protected from the liabilities of your business. The problem is that you're taxed twice. First, your company is taxed, and then you as an individual are taxed. The sweet spot for most people is going to be to set up a limited liability company because you've got a lot of flexibility in terms of tax treatment. You can be taxed as an individual, or you can be taxed as a corporate entity if you want to be taxed as an S corp. But as a limited liability company, you can have the preferential tax treatment, but your personal assets are still protected from the liabilities of your business. There are some important things you need to do. If you're setting up a limited liability company or a corporation, you want to make sure that you are keeping your financial records separate from your personal accounts. You want to have a separate business account. You want to use a dedicated credit card for your business expenses. You don't put personal stuff on your business card. You don't charge business expenses on your personal card. You pay yourself out of your business account into your personal funds. You don't commingle those funds. All of those things are really important to do in order to protect that separation. But if you separate that out, you can protect your personal assets from the liabilities of your business. Errors and omissions insurance is super important because if you make a mistake, or even if you don't make a mistake, but you get sued, your errors and omissions insurance can cover the costs of defending that lawsuit, depending on what the terms are of the policy. There are a lot of people who say to me, oh, my host agency has an E&O policy that covers me, so I don't need to get my own. I think that is a huge mistake because if you have a host agency that has an errors and omissions policy that covers you, it also covers the hundreds or even thousands of other businesses that are hosted by your host. And if somebody else has a claim that could eat up all of the coverage limitations, there might not be a whole lot left for you if you have a claim that comes after theirs. If you are hosted, your host agency might have a requirement that you add that host agency as an additional insured party. There is nothing nefarious about that. It's just ensuring that if you get sued and they get dragged into it because you're booking using their credentials, that they are also covered by your policy. It doesn't cost you any more to add them, but it ensures that the host agency that is providing support to you is also protected if something goes sideways. And I think for your business, even if the smallest travel businesses, if you're getting coverage, $1 million in coverage is probably the least amount that you would want to get, even if you're a small agency. Last time somebody looked at it, I think it was like $30 a year difference to get $1 million in coverage versus 500,000. So just spend the extra money. Consider it a cost of doing business and make sure that you've got the right insurance in place. This is really, really important because I'm seeing lots of people who are coming to me and they are wanting to be large and in charge when they sell travel. They don't want to disclose who the supplier is because they don't want their clients shopping around for pricing, to price check them. But it is critically important that you identify who your supplier partners are when you're booking trips for your clients. Courts require you to identify the supplier, because if you don't identify the supplier, then the court will assume that you are the supplier, and then you become responsible for every electrocution that happens in a hot tub, even if you didn't have control over it. If your terms and conditions have a provision requiring your clients to agree to the supplier terms, you're covered. You don't have to rub their nose in the supplier terms, but you do have to disclose who the supplier is. And again, we would put in your terms and conditions that the client understands that you are the booking agent. But in order for them to truly understand that, you need to disclose who the supplier is. You don't want to turn yourself into a tour operator. And that last little bit there about disclosing the supplier, that is the critical difference in terms of what constitutes a tour operator. There's not a bright line definition, right? So all of these factors, if you host and escort groups, if you take net rates and mark it up, if you handle client funds and client money flows through your accounts, and then the client pays you and then you pay the supplier, if you bundle elements of a trip together and charge one price for it, all of those things are factors that can lead to a conclusion that you are a tour operator. But the number one thing is if you white label trips and you don't disclose who the supplier is. And the lead court case on this is Van Rossum versus Penny Travel, where a New York court essentially determined that because the travel agency didn't tell the client who the supplier was, that it was reasonable for the client to assume that the travel agency was the supplier, and they were on the hook for everything that happened and went wrong on that trip. So again, if you've got a client that's getting into a hot tub that's got an electrical current running through it, you don't want to be the supplier. You want to disclose who the wholesaler was that you booked that room reservation through. You want to make sure that it's clear to them what your role is. And so don't turn yourself into a tour operator unless you've got a lot of money to pay for the things that you need to pay for if something goes wrong. So again, the key takeaways here, all of this can be managed. If you choose the right form for your business, for most people, I think that's going to be an LLC. Get your own errors and omissions insurance, even if your host agency has one. You need strong documents like a good, solid terms and conditions document, custom drafted for your business, not a cookie cutter tool that you purchased or that you're renting that was not drafted for your business. A good, solid client agreement, and then make sure you've got a good workflow and that you're using solid tech tools. So that is my whole thing, and I'm seeing that there are a bunch of different questions here, and so I'm going to try to go through some of these. And I wasn't looking at these as I was going through because I was in a different screen. So Helen's asking, how would you word that disclaimer in terms and conditions? And I'm assuming we're talking about the disclaimer of liability. Basically, gosh, I'm not following because that was a while ago. But Helen, if you just want to elaborate, I'll come back to that question. And it's nice to see you, by the way. Checking a box, Arlene, is sufficient as long as there is a link to where they can find the terms and conditions. If they check a box that they've agreed to your terms and conditions and submit that form, that is great. If you have an e-signature function that you can attach to that, that's even better. But I have a strong view that you want to be easy to work with. You don't want to be rubbing your client's nose in a bunch of legalese. You don't want them to feel like you're treating them like a transaction. So you can fully protect your business without rubbing their nose in 11 pages of legal stuff. Single member LLCs, that is fine. Talk to your accountant. I'm not a tax attorney, so you should talk to your accountant about the tax implications of that. But again, there are such things as a single member LLC. That is better than being a sole proprietor. You get the same tax treatment, but a single member LLC should work. Melinda, it's great to see you. In terms of switching to an S corp, that's really a tax question. And again, I'm not a tax attorney. And everybody's tax situation is different. So I would talk to your accountant about that, or your tax attorney, tax professional. Helen's asking about tour operators. If you book a group cruise and you're going on the trip as well, if you're doing a simple come with me trip on a cruise, I don't think that alone is going to be something that's going to move you into the tour operator lane. However, if you are chartering a ship and you are taking money from your clients and that money's going into your bank account and then you're paying the cruise line, that would be, and you're escorting the trip, that's a whole different situation, right? So even if it's a partial charter, if you've got a large group there, you're not necessarily considered the tour operator just by virtue of the fact that you're going on the trip with your clients. But if you're doing a lot of those other things, like taking the funds directly, failing to disclose the supplier, those types of things could move you into the lane of being considered a tour operator. And again, the big one is, are you disclosing who the actual supplier is? Is it okay to identify the supplier in the final documents, but not at booking? I put it on the invoice so that they see it when they. So right now I'm using TravelJoy in my travel business. I may be switching over to Tern, but for Tern in the near future. But as far as invoicing goes, when I build an invoice, the supplier is always identified on that invoice so that they know before they pay for it who the supplier is. But the important thing is that it's disclosed to them at some point. So I think the sooner you do it, the better. But if the only place you can do it is in the final documents, the final itinerary documents, I think the problem with that is it kind of undercuts the idea that they made the decision to use that supplier, right? That they approved the supplier. Because again, in a situation like where there's damages or where there is where there's an injury, if they're saying you sent me to that resort, so it's your responsibility, you should have known. If you tell them who the resort is before they pay for it, then that undercuts that argument. So I think the sooner you can do it, the better. Melinda's asking about insurance. If the clients don't buy insurance and they say in an email that they don't want it, I do a couple of different things on insurance. So I have a provision in my terms and conditions document that says that the client understands that insurance is available, that if they have questions about coverage, they should ask the insurance company, that it's their responsibility to know what's in the it's their responsibility to know what's in the policy. If they submit a claim and coverage is denied, I'm not responsible for the denial of coverage just because I sold the policy. So it's in my terms and conditions document. I also put it in the client agreement that they check a box acknowledging that insurance was available to them and that they had the opportunity to put it in place. I send them a quote whether they ask for it or not. And if they decline it, I send them the form saying I've declined insurance. So that way I'm covering it 4 different places: terms and conditions, client agreement. I've got a paper trail on the quote, and I asked them to sign a waiver. If 1 or 2 of those things slip through the cracks, I've got 2 or 3 other places where I'm picking it up. So I think that's going to be sufficient to cover you across the board. Are ICs covered if they use the host's TC? So, I mean, there are different types of independent contractors. So if you are a hosted business independent contractor, and you have your own business name and your own business branding, you're going to need your own terms and conditions document. If you are a sub-agent and you're selling under the brand or the nameplate of your of the company that you're working with, that you're contracted to, that would be you should be using their terms and conditions. If you're a sub-agent selling under the brand of another business, don't go off and get your own TCs, because if I were the agency owner and one of my ICs did that, I would be freaking out that they've got something that's inconsistent with what I want them to use. Oh, okay. Helen's clarifying that regarding the liability of not being knowledgeable about the circumstances. So there's boilerplate language that I put in terms and conditions documents that says that because you're the booking agent and not the supplier, that you are not that it's ultimately the supplier's responsibility. There's boilerplate language that's in your terms that should be in your terms and conditions that talks about that. I will say that if you have any specialties, if you're holding yourself out as a specialist in a certain area, there might be things that I would put in your terms and conditions that I wouldn't include in a general agency's document. So, for example, wellness travel. If you specialize in wellness travel and you're holding yourself out as I am an expert in wellness travel, I would want to put some language in there that specifically says that you're not responsible if they experience, if they don't get well, or if they, if they, if the treatments that they're having aggravate a pre-existing condition, those types of things. So I would put something in yours that, if you just occasionally sell a wellness travel, if you just occasionally sell wellness travel, you're going to be covered basically. But if you're telling the world I am a specialist at this, they have reason to believe that you have heightened knowledge or expectations that you know more about it, and so you would want to disclaim that knowledge. I have a couple of clients that do culinary tours where they specialize in either gluten-free travel or vegan or vegetarian travel. If I know that that's something that they're specializing in, they're telling the world I'm a specialist in allergy-free travel. So I would want to put something in their terms and conditions that say I'm not responsible if the restaurant or the cruise ship doesn't adhere to your dietary restrictions. If you are just if you're not telling the world that you're a specialist, you don't necessarily need that language. But and I think actually you would not want to include it in there if you're just a generalist, because then there's the question about, well, why did you put it in there if you're not a specialist? But but again, if you're telling the world that you're an expert in something, there's a heightened expectation. So just keep that in mind. Barbara, hi Barbara. The terms and conditions document is a different document than a client agreement. A client agreement is the terms and conditions document is the boilerplate for all of your trips. It is covering you across the board. The client agreement is really just a vehicle to get people to sign on to your terms. It's the form where they check the box that they agree to your terms. It's the form where they check the box that they agree to your fee structure. It's a lot more user-friendly. It is legal. It is a legal document because they're agreeing to something, but it doesn't have the chewy legalese that that is designed to protect you. Hi, Margot. State by state variations. Okay, so in terms of state law, there are a couple of different provisions. One provision is a choice of law provision, which says if there's a court case, what law does the court apply? And then there's the choice of forum, which is where does the lawsuit get filed? So hypothetically speaking, you could be in, well, because I know where you are, you could be operating your business in Delaware, because Delaware is where you live, where you work. But for whatever reason, it could be that the laws of Pennsylvania are more favorable. So you can say to your clients, if you're going to come after me, you have to come after me in Delaware. But the Delaware courts have to apply the laws of the state of Pennsylvania. So that's a thing you can do legally, but you're going to need to talk that through with somebody. So this is being recorded, and it'll live on my Facebook page after we're done. It'll also be on my YouTube channel, where there's some other videos that I've done that have been recorded. And hi, Ashley. Mary is asking if I'm an IC operating under an LLC, what's the best way to protect your assets? So if you are an independent contractor of another agency, you don't own the agency that you're booking through, You probably have an independent contractor agreement with the owner of that agency, and that would govern what happens. Probably if there's some sort of lawsuit, the agency's going to get sued, and then you would be responsible to the agency based on the terms that are in your independent contractor agreement. So I'm not sure whether that is answering the question, but you'll let me know if it doesn't. So again, I'm just going to go back to, just a couple of things. Am I taking new clients? Good thing I made the attorney advertising disclosure. Yeah, my calendar is backed up a little bit for complimentary consultations right now, but I'm happy to do a 15-minute consultation with you if you'd like to talk about putting documents and policies in place. It might take a little while to get on my calendar, though I do have cancellations from time to time. I'm working on that. Once we do the complimentary consultation, if you decided to hire me, putting a terms and conditions document actually doesn't take that much time, because I've got a couple of other attorneys who are really, really fantastic who can do a review call sooner than I can. They take they take great care of people. But you can email me at tcarpenter@carpentertaylor.com. You can submit a form through our website. My practice manager, I'm going to just post her email address here, Colleen McHugh. She can also make sure that you get on my calendar. This is the sound of me typing and talking at the same time. Okay. So I've just put that there. Yeah. So if you're interested in talking to me, I'm more than happy to talk to you about documents and policies and how I can help. But there's a lot of in recent years there have been a lot of new people coming into the industry. So I know a lot of this is probably duplicative of other webinars that some of you have seen. And certainly if I'm already representing your business, I got you covered. But if you're interested in talking to me about helping out with this, I'm more than happy to have that conversation. I think we're pretty close to wrapping it up. So thanks very much for reaching out to me and for taking time to attend the presentation. Anything you need, we're a phone call or an email away. Just let us know, and have a great rest of the week. Oh, and I should have said too, happy Juneteenth.